just so everyone knows, while we're waiting for everyone, I'll tell you why we've done these, okay? I tell all our agents, when you have to call us, this is when you know, because you're banging this on the table. And if this comes off, that means you know who you have to call. So that's what we tell everyone. Or if, you have children that want to have a good time, just, go to town with these things. I've given my son a couple, and he's broken a few, so be careful with it. I think we'll give it 5 more minutes or so just to check in, just to make sure if there's anybody coming in. I know the parking lot got filled quickly, so I think we're in Toronto. I guess you should be happy there's parking, I guess.
Say downtown there isn't any parking lot.
So, our office, we have a lot of parking, so if your clients ever have to come visit us, there's parking. We're in Mississauga. We're right off the 401 at Mississauga Road.
Okay.
So if you guys ever in that area and you see the RBC buildings, we're right by that.
Are you guys mobile too?
Yeah, we're mobile, and we also do a lot of things virtually. We prefer that because, we all have families, right? And so does our clients, and we know that a lot of the times no one wants to talk to us at 11 o'clock in the morning, right? You really want to talk to us at 6 p.m. or 8 p.m. when your kids are down, right? So my staff laughs at me. It's like, what time, when I tell them that my appointments start from 8 p.m. to 11 p.m., but I'm like, it's when clients love it, right? Yeah. They'd rather put their kids down and then focus on talking to someone, right? Mm-hmm. So we try to give that advantage. Plus, it helps me so my wife doesn't hang me when I come into the house.
How many folks in your firm?
We have 4 lawyers, and we have a bunch of other office staff that help out. Yeah.
Okay, I guess we're ready to roll.
We're good to go?
Yeah.
Okay. So we're the Litigators. Thank you for coming. This is Robbie. He's a lawyer at our firm. My name is Micah. That's Dominica. So if you ever call in, you want to talk to someone, she's your main point of contact because she will be the gatekeeper, as I like to call it. She likes to make sure that, if anything's calling, it's important and gets to us, okay? As I mentioned, we have given you guys some notepads. If you want to take any notes or ask any questions, please do write it down as well along the way. And there's some coffee and donuts. Hey, Sandeep, how are you, man? So if you guys please have a donut and coffee. We're here to talk about litigation issues and things that come across for agents along the way. We're broken it down to 3 different categories. One is, what you guys face as issues when you start your transaction or close your transaction. The next thing is we're going to talk about the law. There are some cases that we have been part of that we have changed the law on, and we're going to talk about that so you guys understand it, because the market could be hot, it could be cold, but these are very important cases that you guys will deal with along the way. And then finally, we'll talk about some landlord and tenant stuff, because that could come across your desk or it could not, but it's good advice for you, especially if you're dealing with situations where you're going to be able to put a tenant in or dealing with a tenanted property, okay? And then we'll take questions at the end. But if there's something that you want to ask right away, the gavel is yours. Just bang away, okay? So a couple things. One is disclaimer, because why would you not have a good lawyer if you're not going to have small fine print, right? So let's pretend like we all read this, but it's basically a disclaimer in regards to what we're talking about is informative use. It's not really legal advice. If you want some legal advice, you can set up a time with us and we can go through it, okay? And then about us, our fancy headshots that we paid someone really big money for. So please, balk at an eye at that, right? There's our pictures. A little bio about us and who we are as people. We like to share our information. We did go to school to be here. We're not anybody that's actually just, got something printed like Mike Ross from Suits, okay? So don't worry. So we'll jump into a couple things. We'll talk about post-closing issues first. And the reason I talk about this is because this happens all the time. There are countless amount of times that I get a call, it's 7 p.m. at night, Micah, my fridge is not working. Well, we talked about this, and I tell my clients this all the time, we talk about it. And the reason we talk about it is because there are avenues that I'm not sure if you agents know or have dealing with this all the time, because this happens. You check the fridge the day before or the morning of, and it's working, but it's not working now. So what do? Well, there's actually a couple of things that we offer. One is, obviously, agents, you guys always recommend a home inspection. We know that, but different markets, you can't have that happen all the time. Let's be real. It's not possible every time. And even if you do have a home inspection, it can go bust. And then the clients are calling you and you're like, make the client happy, cut my commission check, or what do I do, right? So title insurance does help in this. They do offer a program where they do protect for appliances, but there's also home warranty confirmations that they apply, and they do. So when our clients close with us, we offer them this. We say, look, the title insurance company is charging you a small amount of extra money if you want to make sure that your appliance is covered. Now, these are not like one of those scam warranty companies that are out there where clients call us to fight against, but these are more of like protection issues, which we've vetted and made sure that they're valuable. So if you ever have this issue, and you're using a lawyer in a transaction, just make sure you ask them like, hey, if you have a suspicion that the appliances are old, maybe talk to them about, looking into this through the title insurance companies. Chicago Title is the one of the biggest ones that do offer that, and they do have a good connection for the warranty. Then let's talk about property tax issues. Now, this time of the year, the beginning part is where I see the most issues, and I'll tell you why. It's because it's the interim portion. January, February, and March is where the biggest issues happen because it's like my bill is estimated, right? January, February closings are all estimated. If you're not in the city of Mississauga or not in London or not in Hamilton, you're not getting an interim bill till about the middle or end of January. So when you're closing early on, you might not know what that interim amount is. So how do you protect yourself? Well, we do something called, we pull a tax certificate. The slide should have been that, but it's not. It's okay. So we pull a tax certificate, and that also gives us the utility information. Now, you might be saying that's a big expense to clients. I'll tell you right now, $50 is not a big expense when you're chasing for a $100 bill or $200 bill. And yes, title insurance protects you, and it is something that does protect you from it, but why have that hassle and that stigmatism that could have been protected with a $50 expense? So we take that expense on for the clients because we want to make sure that when we close, they know what the interim amount is, they know how much they're going to pay, and they know that it's all paid up and there's no issues. Now, don't get me wrong. It does happen that we do find out down the road that some things don't get paid, but 99% of the time when we get a tax certificate, we have that issue dealt with prior to even closing. Prior to even the day of closing. We know it well in advance. And for that nominal fee, it's worth it, right? And we tell agents, if you're not going to use us to close, that's fine, but push your lawyers that you use with to pull a tax certificate. Because title insurance, yes, protects you, but no one wants that stigmatism for their clients. No one wants to be like, oh, you told me to go to that lawyer, or that lawyer did this, or you've now messed up my closing and I'm stressed about a $10,000 bill that could have been avoided very easily. Also, we are in Toronto. The speculation tax, right? The tax with regards to vacant properties. The tax bill, if you pull the tax bill, it doesn't tell you that. But the tax certificate tells you if the tax is applied to it or not. You can't rely on a declaration sometimes from the vendors. We don't believe in that because you know what? Sometimes when you're signing, you don't even know if the lawyer even told you that's what you're signing about. So when you pull the tax certificate, it'll tell you if they've declared or what they've declared or not. So it's always good to do this. It's an extra step, but it's worth it in the long run. And now other cities are looking at doing this, so it's going to be big for other people, right? Like Ottawa's doing it now, London's doing it. So, when we're closing these transactions, we're pulling it for sure. There's not a transaction that we don't pull it. Dominic, how long does it take us to get a tax certificate?
Sometimes 3 days.
See? It's quick.
Sometimes like the same day we'll get it.
So it's worth it, right? And it's nominal cost for everyone involved. So I'm going to pass the mic to Robbie. He's going to talk about a few things.
So I'm Robbie Seacon. I'm a litigation lawyer. Obviously, Micah, you can tell he does a little bit of everything, but I strictly do litigation. So let's just open up the floor to you guys first. What are some issues that you guys face when closing in terms of litigation? Can you guys think of anything? Any possible litigation?
Tenants not moving up.
That's a really good one.
Child's missing.
For sure.
Who took the fridge?
Something like that, yeah.
Anything else?
There's the issue of and even a lot of agents may or not have experienced it. It doesn't happen often, but if a closing doesn't occur, you have a deposit there, and a lot of people assume that okay, it didn't close, the deposit's mine.
Of course, yes.
In my experience, that's the wrong assumption.
Definitely.
Because it takes a mutual release of that deposit, and it goes to a litigation. costly litigation, right? And so, for us, it's sort of that understanding and being able to tell our clients that or explain that to them ahead of time.
And
To
definitely,
protect yourself, from that potential.
for sure.
occurrence.
And we're going to show you some new case law that kind of jumps into that deposit part, but
Right.
we're just going to go to the first slide here.
Yep.
So right now, obviously based on market trends, there's a lot of buyers now that can't secure that funding. I get this phone call at least 2-3 times a week, right? And it's just crazy. Like obviously you guys know how the market's going right now. And the first thing the buyer is looking to do is to blame everyone but themselves, right? And one of the first points of a sale are obviously you guys, the real estate agents. So we want to make sure you guys do all your due diligence beforehand so you're not on the hook when this litigation comes through, right? Because you guys know they could be on the hook for the full purchase amount. So obviously what we're trying to establish here is what are the things you guys can do. So obviously stronger due diligence, verify pre-approvals and confirm lender reliability. This is massive in terms of securing that finance, because at the end of the day, some of the things we're actually seeing are a lot of agents are just pushing these sales through and not checking all these things, right? Or they're even pushing them to their own lenders, right? So at the end of the day, the buyer might come after you guys to try to kind of get that litigation going, right? And another thing is larger deposits. So ensure buyers put down a meaningful deposit. The more you put down, the more skin in the game they're going to have. Obviously, financing clauses, make sure that you guys explain everything, right? Clearly define financing conditions and deadlines in APS. Obviously, there's a lot of litigation that comes from agents not explaining the APS thoroughly, right? So make sure you go through all these clauses. It's very important. And obviously, communicating with lawyers, ensure all payments and instructions are clear and irrevocable. And again, I think you guys are in a very competitive market. So I think what deciphers you from other people is the knowledge you guys have going into these things. Litigation matters, explaining everything from A to Z, right? These are the things that are going to help you guys when you guys are educating the clients. And obviously warning buyers of risks and consequences of failing to close. So here's an interesting case that we had a hand in dictating. So the purchaser did not pay the deposit within the 24 hours and our clients resold for less. So what do you do?
Anybody?
Sue for the difference.
Okay. What else? Do you get a mutual release?
No,
Do you know why you never get a mutual release?
you can't
Because
sue
then you
them if
can't
got
sue
mutual
them.
release.
Exactly. It's basically a binding settlement agreement. So never get a mutual release when you're in this situation, ever. And always consult a litigation lawyer what to do next, because every step you take matters. And I'll tell you why, especially in this case. We actually got the judgment on this. It's now settled law. It's like the #1 case that everyone uses. We just got it last year. And essentially, the client contacted us within 2 hours of knowing what happened. And we managed that situation from this point. We never closed the real estate. We just did the litigation. And because they did, they got what they got for that reason. That's why we always tell agents, there's real estate lawyers and there's litigation lawyers. Go to a litigation lawyer when this happens, because they will manage it to the T and make sure, one, that you're protected and you're going to get what you get. So
Are you saying that the client actually got?
we'll explain right now. We're going to explain right now. Yeah.
No, I'm just saying.
Noise. So obviously here's the facts of the case. The offer was accepted for $635,000 for a Burlington property. The buyer backed out the next morning, and obviously in that case, a deposit wasn't paid. And then the property was sold later on for $12,473 less. So we were actually able to go to court and actually get the deposit secured, even though it wasn't paid, because this is showing that in a contract, you need performance. So once you sign that dotted line, you are on the hook for that deposit, even if you don't pay it. So we were actually able to secure the deposit and the vendor protection as well, and also prejudgment interest and the costs as well. So it wasn't just the difference, it was also the deposit as well, plus our legal costs as well. So obviously the key takeaways here are, do we have any questions here?
Yeah, I was always under the impression that you couldn't relist a property unless you had the mutual release signed.
You don't.
That deposit wasn't paid.
No, even if you don't have a deposit, you can still relist.
You can relist. You can't
Because
close.
no, you can close. Because the key to it, the key with you can't relist is you have a binding agreement, correct? When they don't follow through with what they're supposed to do, it's done. So what has to happen is you have to write to them with or without a lawyer. You write to their agent because you won't have their information and say, you are now failed to perform your contract. We are relisting the property for sale. If you do not deliver the deposit, you have to give them, and you have to use the words, we're ready, willing, and able to close. If you do, you can go ahead and do it because they're not following through what they're supposed to do with the contract and they're in breach.
The deposit is a term of the contract.
That's correct.
So in other words, if there's a so-called breach of the contract, as it's a breach of the contract, you are allowed as agent to sell to somebody else, yes?
Correct.
That's okay.
So we've had other lawyers in here, like for instance, Mark Weisler teaches real estate. He's
Of course,
part of Rico.
of course.
Everybody knows Mark Weisler.
Yeah.
And he has said, and he says in his book upstairs, that you still, at the end of the day, the deposit is only one consideration on a contract.
That's correct.
And that you cannot, still have to be released from the initial contract to close on this.
100%. But there's no, if you sign a mutual release, as we talked about
Yeah,
before,
exactly.
it's a full and final binding agreement. If they're not going to put a deposit, what are you mutually releasing on?
All the other terms of the contract.
Correct. But the other terms of the contract means you're releasing them from that contract. But you're not trying to do that if you're going to go litigate.
And I understand that you wouldn't sign a mutual, but you can't close on the second deal.
You can. You're allowed to.
Okay, so Mark says you can't. Okay.
The reason you can is because you've given them the opportunity to close. You're telling them you can close, and if you do not close and you're not fulfilling your part of the contract, you are now released from the contract. Because we need to go and mitigate our damages. That goes into mitigation, right? How quickly did you relist the property? How quickly did you get back on the market? They did it within 2 days.
So you do need to let the other buyers know
Of course.
that you're in litigation and this may not happen for them.
And that's why you hire a litigation lawyer right off the bat, to give them the information and tell them that you either fulfill your duty as of the obligation or not. If they're writing to us and saying, hey, we're not going to close, there's circumstances that are out there, then that's it. They're repudiated the contract. And you take that as a repudiation and you start listing the property for sale. There's words that we use, there's words that we put in, there's certain cases that we put in when we write this letter to them and saying, if you're not going to close and you're telling us you're not going to do what you're supposed to do, we're seeing it as your repudiation, which means that you're no longer fulfilling the part of your end of the contract of closing, and that means we're going to move ahead with someone else. And that's why you don't want to get, like in your situation what you're saying is if there's a mutual release, then you can go ahead and list. That's correct. But if there's a repudiation, you have to let them know that there is, give them the chance to come back to the table. If they don't, you have the rights to go ahead. And this case helps us with that.
So what would be the cost of that litigation?
This costed somewhere around, I can't remember. So the guy tried to appeal and stuff, so there was a little more involved in it. But the initial stages obviously was somewhere between 3,000 and 5,000. And the reason was it was a little higher was because the person was evading service, right? So that was a big thing. But we got the cost involved in this, right? And the other thing was because it was a new setting case in the law, they tried to appeal, right? It's not gone anywhere, obviously, but that's why it went up a little more than it should have. But we helped the client with it because obviously we wanted to make sure this stays for obvious reasons. Because the number one thing here is the law before this was saying you only get the difference. So if the deposit was 40,000, whichever your difference to your sale price is, that's how much you get. This is saying the deposit had to be paid regardless, and now you get credited that deposit. So that's what's changed in this from previously. Any questions? No?
What if they did have the money to begin with?
Like if
And
they,
now you have to chase that.
so we obviously did a preliminary search on the person to make sure that there was equity there. They actually bought a house in the same building because for a lower price. It was that time where the market was hot where you were where a lot of agents thought just put multiple offers. Well, you can't do that, right? You got to put one offer at a time and move on to the next. So we knew that she did that. once we came down to do some searches.
But in the event that they didn't, you would have to take extra steps to chase
To
down the money.
Well, we have a writ on the property, on multiple properties in that she owns.
In that case.
Yeah.
But in the case where, let's say,
First-time home buyer.
first-time buyer or something like that,
You take a risk of they're eventually going to buy, right? I mean, if they've tried to buy once, they're eventually going to buy. So we would, we manage the client at that position and say, you have a 2-year limitation to start to sue, but you have a 10-year limitation on your judgment. So do you continue to renew your judgment until you can get collected or not, right? So it's a cost-benefit analysis to the client at that point, and we explain that to them after we do our preliminary searches and investigation. Anything else? No? Okay. Move along.
All right, so here's another interesting case law we're going to jump into. Can a lawyer withhold commissions from the listing brokerage?
Anybody have an
a
answer?
listing contract that says they have to pay, but there are some lawyers
Yeah.
that will withhold.
They're obligated to do what their clients ask, aren't they?
Well, we're going to see in a second.
Unless
Yeah.
contravening the contract.
We're going to see in a second.
Anybody else have an opinion?
We have a scenario where we had a commercial deal, and it was during the conditional period. We kept extending, and then during that process, the listing agreement expired and the holdover days expired as well. Now the seller was trying to avoid paying commissions, so how would that play in if during that conditional period the holdover and the agreement expire?
So, full transparency, I know a little more details about this. So, because there's 2 things that you have to remember. So, like, one, we always talked about, like, you're out of contract now, right? But the buyer hasn't changed, right, in this scenario. The terms haven't changed in this scenario. Everything's still the same. And because you introduced it, it's like when agents, you have a listing agreement and they go buy the same property after it's expired, you show them that property. You've done the work, right? So in that case, even after the holdover period, right, you can still go after the commission because you've showed them that property. You've done the due diligence with them to do it, right? So in that same case, there is a way to get the commission paid on that, right? Unless the terms change totally, the buyer changes totally, right? Then it's a different scenario.
And what happens if the customer orders or advises the client, the seller advises the lawyer not to pay?
Let's talk about this now.
That's what we're going to jump into now.
Yeah, that's what we like to do.
Don't encourage them.
So this is a case that involved an agent and a lawyer and a commission dispute. So the facts of the case were a lawyer received funds from a real estate transaction. Instead of paying the full commission owed, they paid part of it to the vendor after getting an indemnification. And then the real estate agent sued both the lawyer and the vendor. So in this case, the court ruling ruled in favor of the real estate agent because the APS was signed under seal and the payment instructions were irrevocable. The lawyer had no rights to override the APS agreement.
So answer is, you can't do it. And as a lawyer, you can actually get sued for it. And you will lose. And there's law setting it out for that. So if you ever, and I found this funny because we were talking about this. He's like, how many times does this actually happen? I'm like, you know what? It happens more than we think. It's surprising. Like, I get the lawyer's obligation. You're right. I think one of you said it, right? The obligation to the lawyer is like, hey, you have to follow your client's instructions. But actually, you can't circumvent the law when you're following client's instructions. So what's an option for the lawyer in these situations is there's a dispute. You write to both parties and say, I'm in a dispute. You decide, I'm holding it in trust. Or you throw it into court and say, I'm washing my hands. Because you can do that. We can throw it into court. It's one form, right to the court, put it in, wash your hands, and say, you guys deal with it. I don't want to deal with this. Because at the end of the day, Law Pro will come take $5,000 from you, fight for this, and lose, and then your deductible goes up. So,
What's the turnaround time on something like this?
Oh, that's a good question.
litigation, putting into court, what do you mean?
Something of this situation
Oh, this can go on for years.
Yes.
for years.
This can go on for years.
And then now what happens if it is a corporation that it's being paid to? So like let's say the seller is a corporation.
Yeah.
The money gets released into the corporation, right? And now people with corporations seem to.
Disappear.
Yeah,
Yeah.
you better make sure you have a good lawyer that knows how to put things in place right away to seize things, because otherwise you're done. So you got to get a maneuver done right away, and maneuvers are not given out easily. But in scenarios like this, where you're like, you're not supposed to get the money, we need to freeze, let's move forward, they'll give it to you. But it takes time because no one really wants to give out a maneuver, especially on an urgent motion like that before the money gets moved. So.
We've had lawyers call and more or less threaten to withhold a portion of commission. I mean, they're not holding deposit, right?
No,
On
yeah.
the balance.
Yeah, the
They've
balance,
gotta pay
yeah.
a balance to us.
12,000, 7,000,
And
yeah.
for whatever reason, the seller's not been happy, and they said, we have direction not to pay the difference, whatever it is.
What'd you guys do?
Yell and scream and send the thing and jump up and down and constantly contract.
Well, take
And
a
they pay in the
picture.
end.
Take a
But
picture of this and quote it to him and say,
Don't worry,
go.
I just am going to.
You now have something that you can hold in your back pocket and say, go.
In this case, the lawyer is holding deposit,
This case, the lawyer was not holding the
and
deposit.
not the brokerage was.
Yeah, this is the balance of what was due.
Balance of commission.
Yeah, the balance of commission. It doesn't matter what if it's the balance, the deposit. It doesn't matter. It's your commission that's due. Even if it's $1, they can't hold it. Even under the instructions, clearly because of what the law said. And it was interesting because this is like the setting case. There's so many cases after that. There's even like stuff from like as recent as 2024, right? That have dealt with this case that said this applies. You can't do this. So if it ever happens to you, you got lucky. You got something in your back pocket ready to send to the client and the lawyer. Yes.
I'm curious because it says here lawyers must follow APS payment directions once signed under the seal.
Mhm.
What does it mean? I mean, I understand that any offer which is signed now is under seal. We used to have a seal,
Mhm.
beautiful red or whatever.
Correct.
That if it's signed, it's signed. Yes, is it considered under seal or there's any difference in something?
The seal obviously was back in the day. This case from 1992, as you can see, right? So that's when the red seal was put on, right? Now, when you remember, under seal is when when both parties have signed it and it's done. Now, in the APS now, there's that commission part, right, where it says the listing brokerage information, right? When it's signed under that portion and it's accepted, that portion now plays a part in it. So the new law, what the 2024 cases and all are saying is that portion, right, when it's informed there that everyone's agreeing that there's a commission being paid, and everyone's agreed that the lawyer who's instructed on it has to pay because they're following that contract. As lawyers, our job as a real estate lawyer is to be like, okay, who's the buyer, who's the seller, what's the terms, right? Go through the whole thing. That forms part of it, right? It's not like we can't close on that day because we choose not to. It's the same argument, right? Because it says it's Jan 31st doesn't mean you can not close on you can choose Jan 29th. You can't. Same thing with the commission, right? It's part of it. Requisitions are the requisition, right? Title search is title search, right? The property you're selling is the property you're selling. Any other questions? And to Sandeep's point, his is a little more complicated than this.
We actually got it solidified, so we're good.
Oh, did you? You didn't tell me that. Nice.
And we hold the deposit.
Oh, even
Half
better.
deposit.
After the deposit.
Congratulations. Sorry, Robbie.
no,
that was
that's
supposed
good,
to be
that's
that was
good.
supposed to be a good case for us,
Yeah.
but Sandeep decided
All
he
good,
wanted
all
to
good.
solve it himself.
All good.
So we'll go into something about tenant stuff because I know a lot of people do tenant work along the way, especially when the market's like this. It's a little slow. Why not take, a little bit money in the pocket, right? So, question. You found an amazing tenant. You signed in a rental application, so the area form. What do? That's it? Take the deposit, run? Go to the bank?
No, you gotta do the standard lease.
Anybody else?
That's still after the fact.
Anything else?
I don't understand. Send a rental application.
Yep.
Well, you gotta do the agreement.
Correct.
That's number one.
Number one.
Terms and agreement, deposit, all that stuff.
Mm-hmm.
And you've already done the rental app, you've done the letter of employment.
So what do you do?
Your credit score, your.
So technically speaking, once you have the rental application, you don't have to do the arrear form. You do have to do it because you're agents, right? And you have to do it that way. Yeah, you have to do it that way.
For RICO.
Correct. But if you're doing it on your own and you're not doing it that way, you don't have to do anything, right? You just do the application and you can.
And the standard lease.
There you go. Do you know how many times I have had clients come to me with just the rental application and the arrear form? That's it. It's against the law. You have to have this standard lease
For
form.
landlord's
Yes,
obligation.
totally redundant,
Exactly.
100% redundant.
It is redundant.
Paper.
It is, but don't have a choice.
Sorry.
You don't have a
Well,
choice.
you know how I feel.
You don't have a choice.
Surprise.
I agree with you 110%. But there are two things in here that are very important when it comes down to litigation in landlord-tenant board. One is the notice of emails. You don't know how important that is for us as people that go into landlord-tenant board and fight that. Because if it's not clicked off and it's not there, we can't use it. But if it is, everything is floodgates open. You can send everything, enforce everything. And your service times are just gone way quicker, right? So that's why I tell agents, please have it. Make sure you do. And it seems like everyone in this room is well ahead of me, so thank you.
Actually, I want to point out, if I'm not mistaken, I don't think the standard lease covers mobile home parks and land lease communities. But it says
Why do you have to harass everyone in the room?
I noticed that was brought to my attention, so it does not cover.
Yes, we know. Yes.
Right?
Yes. It doesn't
Just wanna
cover
let everybody else know.
because you're dealing with a unicorn.
He is a unicorn though.
Now you know what to get him for Christmas. Unicorn head. Okay, couple questions. Is it legal or not? Let's play a quick game. And whoever wins gets a box of donuts because no one's touched this one. I received 3 months of prepaid rent. Legal or not?
Illegal.
Illegal.
Okay,
First and last one.
that's correct. Can you take, though, 3 months of prepaid rent?
Yes.
Yes.
Based on what?
On
The tenant
the tenant, if the
Correct.
tenant
Offers.
it.
And how do you protect your clients for that?
saying that the tenant voluntarily offers
And how do you do that?
in a clause.
Exactly. Oh, you guys are way smarter than I am. Look at that. I asked for a damage deposit of $1,000.
Illegal.
Correct? Can you ask for any sort of deposit for damage?
It's like just a key, yeah.
Just a key.
If it's true, if it's a fact.
But even the $500 is too much.
It is. So this is exactly. So this is incorrect. What you can ask for is based on what the condo corp sets the amount for the FOB is. Replacement cost for the FOB. It's actually not even the keys. You can only actually ask for the FOB portion of it. People do throw them in together. Landlord-tenant board hasn't really balked at anybody that's asked for it lately for both, but really it's actually just the FOB, right? And even if you have a residential tenancy in a non-condominium setting, you actually can't ask for a key deposit. Only if it's the FOB with the condo corp, or if there's a property manager involved that has some specific kind of mechanism, they allow that.
Yeah, so
Yeah.
if the keys, like in condos, you can't just go to the local store and get them cut.
Correct.
Right, so those ones require you have to buy through management.
Yeah.
So can you get a deposit for those?
Yes.
Yes.
Some condo key also you cannot just go to any hardware store to duplicate. You have to go to a certain.
Yeah, that's what he was saying just now. Yeah, you have to go to the
Yeah.
media keys.
Yeah.
The last thing is I increased rent after 6 months. Is it legal or no?
Illegal.
No.
Correct. Unless you're in a month-to-month. What about that?
Still illegal.
Exactly. Why?
1 year.
Every year.
It becomes a 12-month tenancy regardless of the fact. Okay. Last thing. When you should hire a real estate lawyer? Well, you guys know that answer, but do you know what the answer is when you should hire a litigation lawyer?
No.
No.
When things go
Should have them
south.
on speed dial.
Exactly. Things go south.
But you usually try to fix it before you need the litigation lawyer.
But have you ever been in a situation where you could call someone and say, hey, I have this problem. What can I tell my clients?
Yes, I have been in that situation.
Have you ever had to call someone? Who do you call? The real estate lawyer?
Yes.
Shouldn't. You're calling us. Because the real estate lawyer is not going to take that file from your client and say, let's go sue, right? They're not the one advising. If it, God forbid, has to go down that path, what are you going to do? Right? So we're obviously a full service firm. I do a lot of real estate, does a lot of litigation. I do a lot of litigation as well. And, we try to put ourselves out there that, if you call us, we're obviously going to pick up and help. You don't have to give us closings, but if you ever need help, we're obviously there for your clients and say, this is my question. What do I do? We'll help you. We'll give you the advice because we give clients all the time advice when they call us in, right? So we have no problem helping you. If it's 6 p.m. at night, 7 p.m. at night, we'll help you figure that transaction out. Do you know how many times people have walked in the house and says, there is now damage under that couch that was there,
Yeah.
right? Yes.
Question. So let's say you have a real estate lawyer and things have gone
South?
south. What you just ask them, like, can I actually go and, talk to a litigation lawyer, or like, I just directly bypass him and call you guys? Like,
Why not? realistically, you're not stepping on their toes because now it's out of their hands, right? There are a lot of times where our emails are CC'd with the real estate lawyer on there and saying, we're taking over from here, right? He's going to close the transaction, or she's going to close the transaction, but we're going to negotiate this issue until resolution, right? It happens tons of times. We do it every day. And the reason is because everyone's got their own expertise, right? That real estate lawyer that you might have that expertise. I'm not saying he won't, but if it has to go to litigation, you have to ask them, are you going to sue for my client or not? Are you going to be the person to do it? Because if you're not, let's go to the person that's actually going to do it and solve the issue, right? It's no skin off your back, right? You're helping your client out at the end of the day, right? And it could be one email from us that could solve it sometimes, right? Or one phone call being like, no, this is what you should do, right? You never know how many times you call us, but that one time we actually click and make some money off it, right? So we don't mind, right? Yeah.
I would like to go back to the beginning when you were said, that we have to explain the buyer. Let's say we have a buyer, yes, and he put an offer that you explain him all the kind of circumstances. What if you don't do this, this, and that? So then you try to protect yourself. But we recently had a transaction where the buyer's agent put a clause that whenever transaction is done, it's conditional upon the buyer's lawyer approval. Is it something just like to be on the safe side that we should always put this clause, or whenever we have a client who you think that we may have an issue? I understand that this is for the pretty much agent's protection, yes? Because, okay, it goes to the lawyer, so what that lawyer is checking, I mean, the legality of thing, or like what can come out of that, like buyer's approval?
Yeah, so that we see three different types. If it's a commercial situation, right?
Let's suppose a residential. Right?
It could be an estate file. Was it an estate file? Like an estate?
No,
It was just regular, or
regular. On the seller side, we were dealing with a power of attorney.
that's why.
Yeah.
That's why.
So why? Why?
The lawyer has to review it because it's a power of attorney situation. Make sure capacity. They have to verify it because when the lawyer registers the transaction, they have to register the power of attorney as well. So they are putting themselves in a predicament because we have to click a statement in TerraView that says we've verified the power of attorney. We've explained this to the transaction. We take on a liability perspective on it, right? So that's why 90% of the time the lawyer will tell the agent, I need this clause in there to verify the deal to make sure it's okay.
The lawyer says that, what you just said, he said.
The person that's using the power of attorney. So like if I'm closing on a power of attorney, if my clients are closing on a power of attorney, we click that statement off in TerraView.
So if he had
Sorry,
a
I'm still
property,
confused. Are you acting for the seller or the buyer?
The seller. I would act for the seller of that situation because they are the ones with the power of attorney. They're selling it with the power of attorney.
Is that the same as executors?
No.
No, different.
Okay,
Executors are people that are selling from an estate.
yeah,
But we have a different statement that we click off on that as well when we're doing an executor situation.
We actually put an offer in last night for a property for power of sale. So we had to put a lawyer condition in there for that reason as well, to make sure that the previous owner has no recourse in coming back if they accept this offer and do this.
So there's usually a clause when they're taking their power of sale.
So we just put in a simple seller's lawyer review clause, and then they can word it and do what they need to do on our end, their end. But they wanted us to submit that
don't
clause.
they technically have first dibs on it if they
No,
can get?
not always.
Not always.
would you also use
Not
that?
right of
But
redemption,
we
not
did
everybody
use
has
power
right of
of sale.
redemption.
Yeah, but you usually want to have the right of redemption regardless available on those power
That's
sales.
what side of that you're on.
Just put a seller
Yes.
clause.
Sure, fair.
Seller lawyer review, otherwise you never have a seller lawyer review.
Any other questions? Yes.
I was really very interested to hear about the one where the deposit was paid and the deal didn't close.
Okay. Oh,
Very interested to hear what you have to say about that.
like we did. You want me to tell you more about it?
I think the example you gave was a little different.
Okay.
We have the deposit
Okay.
in trust.
Yep.
The deal did not close on closing day.
Yep.
So we have continued to list the property.
Okay.
Potentially an offer's coming to me today.
Okay.
What do I have to do?
You've not done a mutual release,
No.
I'm assuming.
Did not get a mutual
And
release.
when the transaction failed to close, I'm assuming the real estate lawyer wrote and said, you're not tendered, you're repudiated, you're off. So that's perfect. So you don't have nothing to worry about then. If they've done that letter, make sure the client has that letter in their hand, because that real litigation lawyer is going to need that. Okay. At this point, you just go ahead, take the offer, and close. Once it's closed, we take all the calculations because there are obviously going to be carrying costs that are going to have to be added onto this.
Yeah.
You're also going to have to probably maybe staging cost extra. I'm not sure, right? If there's a bridge loan involved, I'm not entirely sure. So those are all things you have to add it, and then the difference in sale price if there is.
Okay.
And then we would just take all that information, sit with the client. We would do a search on the potential buyers, make sure they have something. If they don't, we can't find them. We give them the cost breakdown.
Sorry, potential buyers.
On the previous.
The previous buyers.
The previous
The
buyer.
initial buyer.
The
Okay.
initial buyer, if they have anything available to them. A lot of times they might, right? They might at least have a job that we could find, right? So if that's the case, then at least that's worth litigating. Because if it's not like working at Tim Hortons, it's something more serious, then it's worth litigating. Because then the garnishment you can do on them. And once the garnishment starts, they'll come to the table. Always. 9.9 point out of 10.
They're really lucky.
Can the initial buyers come back with now she's accepted a second offer? Sorry, I'm playing.
No, that's why she
Okay.
that's why I said the real estate lawyer had to say that you were
Okay,
getting the contract.
That's right. I just thought then you have two offers.
Yeah.
I usually retain that letter from you too.
I'm sorry?
I usually get a letter.
You keep
copy
that-
letter.
okay.
I, as the agent, keep that letter.
Smart. It's a smart move. I normally send it out, like even when we extend deals, I normally keep that on files and I send it to the agent and I send it to the brokerage always because I think you guys keep a file as well,
So
right?
as a little gentle aside, this buyer who is in breach has been back twice verbally, asking if we would take a lower price, actually 3 times.
Oh.
And we've said no, not prepared to do that. She's nowhere near the price that she offered and breached on, okay. And the offer coming in is probably a better offer. Haven't seen it yet.
If it's a better offer, then you're good. If it's not, I would suggest that you try to work with that buyer because they would have a defense with that saying, I gave you a better offer even verbally. You would put it in, I would put it in writing to them and say, hey, by the way, if you're serious on this offer, put it in writing within X amount of hours.
Okay.
Just to protect yourself your client, sorry. Actually, and yourself, sorry, and yourself as well. Actually, and yourself as well, because your buyers will come after you after that. Your seller, sorry, will come after you.
Okay, thank you.
No problem. Anything else from anybody?
Can a buyer litigate against a contract where the seller passed away during the contract? So we're now in probate, and they're trying to give us all kinds of crap. and so just wondering, like, because they still have to fulfill that contract, no?
Yeah.
That it says it in the APS.
Yeah. So technically, they can walk away from the transaction because you can't give title. You can't give title.
We can't.
The
no.
seller can.
Yeah. You're the seller, right? You're representing the
Yeah.
seller, right? Yeah. You can't give title, right? Because you
So
can't
they
transfer.
Can walk away.
You can walk away.
So if you've done a deal that is unconditional, and from unconditional to closing, the seller passes away, you can't close?
You can't give title.
Yeah.
It's in probate.
As
It's in probate.
a lawyer,
Yeah.
right? You the client cannot sign the acknowledgement direction on the day of closing.
Yeah.
Technically, yes, we get it signed way in advance, right?
Yeah.
But that date is as of the date of closing, right?
Yeah.
The A&D that says I'm transferring this property to this person. If
Yeah.
that person's passed away, there's no capacity.
Okay.
Who am I
Why does it
transferring?
have that language on the APS?
On which?
Yeah. On
I don't
the
know, why is that language on the APS?
Sorry, which language do you mean? Sorry.
That the heirs and successors, whatever that says.
Yeah.
Good question. I don't know.
Yeah, that's.
That's
Oh,
where
sorry.
I was going with
Well,
that.
it binds everybody, right? The heirs and successors say you have to follow through with this deal, but as the buyer, they don't have
They
like
can choose to
yeah,
continue.
they can choose or they can't. It's up to them.
Oh, it's up to the buyer. to
Right.
So
choose
if
the
they choose
buyer.
to continue, then they just wait.
Just wait till but you can rush probate. It can be done within 2 weeks.
By the way, how long, because it used to be 6 months in
A year.
Toronto.
If you have a signed agreement of purchase and sale in the city of Toronto, Brampton, or whatever, they can actually even give it to you. Brampton can give me 3 days. I can have probate. Yeah, I can have probate.
Really?
In Brampton, I can have it in 3 days.
And
Be-
what about
Toronto take me sometimes between 7 to 10 days. It just depends on which clerk I get and if I know her well enough.
Okay, so I gotta get on the lawyer.
How long has it been?
That's only been a week.
Oh, okay, so you're almost there.
It's been filed.
Yeah.
So
It's only been a week since
if we have a
it's been
state
filed.
deal,
Yeah.
and
Not
we
since
speak to
we
the
filed.
client, sometimes it's happened, they're like, okay, we're gonna submit for a probate.
Yeah.
Which is taking up to a year.
Can't be. You have an agreement of purchase and sale?
No, without.
Without,
right?
then you have to write to the court and say, the carrying cost is getting too much to the family. The
Yeah.
market's changing. We need to do it now, and they could expedite it. Six months is the longest time we spend on probate. If it's anything more than that, someone's not following up with the court, and it's falling under the pile.
Okay, and then, let's say, for example, if we put the house up for sale
Mhm.
and we sell it,
You have to do it conditional upon probate.
correct, right? So that would be the way to do it.
Yeah.
Okay. And then there's a clause I think we write, subject to probate and stuff.
Yeah,
like that.
exactly.
And can be extended, how many times?
It can be extended.
Well,
Depends.
all parties have to agree to
Yeah.
extend.
Yeah, it can be extended until it's. I see a lot of them where it's like until it's there. Sometimes I see it can be extended for 30 days more or whatever it might be, depending at the sole discretion of the purchaser.
So what about no probate? What's the requirements for not going to probate?
Joint tenancy.
Other than that?
There isn't.
Oh, no?
What,
Okay.
what's that?
Joint tenancy.
Because I've seen people take a listing, say, well, the family told me it doesn't have to go to probate.
Joint tenancy. It's the only probably way.
But it wasn't.
Family trust, maybe?
And, yeah, and it
Yeah.
didn't have any other
So,
assets.
so I heard that that's one way you can avoid probate. If you see that it's coming, that the
Transfer
seller's going to pass away soon, to
Transfer
transfer it through a trust account.
You can transfer to anything
To
at that
avoid-
point.
To avoid the probate.
But at the same time, do you know how hard it is for the buyer at that point to get title insurance when that happens? Oh my. Oh my, it is
Oh,
hard.
really?
Why is
Yeah,
that?
because
yeah.
if there's a transfer within 30 days or 60 days, right, from the day of closing, it becomes a hassle. Do you know how many questions they do? How many times they email us?
A lot.
Oh,
Nonstop.
what?
Like what kind of question?
Like, because it's for them, it's a red flag, right? It's like suspicious, and then you say, "Oh, the person passed away." Oh, that's it. It's like it's like, oh yeah. I mean, we can get it. There's no doubt we can get it. We call the right people, but it does make a lot more extra work for the
So you're
buyer's lawyer.
suspecting title fraud?
Yeah, correct. Right? Did the heirs know all about this? Where's the will? Where's this? Where's that? It just becomes a whole thing.
Yeah,
And so-
speak to the other side,
Yeah.
the lawyers, everything.
Yeah, the whole 9 yards. Talk to everybody under the sun.
So the worst if the seller dies on the property, that's.
No, I mean, there's nothing wrong. There's nothing. It's if they do the transfer within 30 to 60 days. That's when it, or 90 days even actually. That's when it kind of gets a little weird. Yeah, it gets a little murky. So it's always good. If yes, you're right. It saves a lot of hassle, but it can get murky. It can get out of it. We can fix it in like this, but it's a lot more extra work. That's all. Anything else from anybody else? Everyone got a gavel? Anybody that didn't, please come grab one. Have a donut. I'm still taking questions if anybody wants. Robbie, anything from you?
I come more alive in court. He's doing the selling today, right? I'm like the pit bull, right? Just
I don't really
sitting in
have
the
a
corner.
question, but I do want to say I've been dealing with Micah and his team for the last
sorry.
just under a year, and they've been really good with me. Like they've answered a lot of my questions. They are very informative, and I would highly recommend them. So if you guys have any huge real estate or any form of transactions, yeah, please open up and deal with them. And,
Thank you.
I highly
Quick on
recommend.
my phone, I
Thanks.
hope I don't need to use you.